that I have just read out in NFPC and family, why would you be discriminating between judgment debt belonging to private persons and judgment debt belonging to public institutions or public officers? That will mean unequal protection before the law. The argument is that alone is also enough to invalidate Section 84 of the Sheriff and Civil Process Act. I also took a look at Section 287 of the Constitution, which says that judgments shall be enforced in any part of the Federation by all authorities and persons and by all other courts with subordinate jurisdiction to a court that is higher in hierarchy. Now, that constitutional provision 287 enjoys a mandate that all courts, Federal High Court, High Court, National Industrial Court, Court of Appeal, for example, must enforce all judgments of the Supreme Court. And if you now bring Section 84, which brings a restriction to that enforcement of a judgment properly and validly delivered by a superior court of law, would that also not make it unconstitutional? I'm aware that Section 84, 83 and 84 have been subjected to this test of Section 287 of the 1999 Constitution by the courts, particularly the Court of Appeal in Onjewu and Kogi State Ministry of Commerce and Industry, the government of Akwa Ibom State against Powercom Nigeria Limited, and the CBN against Idle Air Property. In all of these judgments, because held that Section 84 of the Sheriff and Civil Process Act was not inconsistent with Section 287 of the Constitution. But I have a problem with those judgments, which I believe the discussants will look at more vigorously, especially when I was having a private discussion with my Lord, the President of the National Industrial Court, and the Chairman for this occasion. When Section 84 is referring to this public officer or public officers, his HIS, will his also extend to an inanimate object, for example, like a bank or like the Central Bank of Nigeria? Will his not simply mean a human being that is life and that has life? That is flesh.
I believe your time is up.
These are the questions I think
looking for the other discussants.
I want to thank you so very much and thank all of you for this opportunity.
Gentlemen, the first discussant is a jurist, no doubt. He has made his mark. Indeed, I will call him a professor of law. He was at the Institute of Advanced Legal Studies. His articles can easily be sourced on the internet. He's produced a book which I believe is parallel to none on issues of consumer protection. And today rounded on the bench. I leave you to be the judge, as you will see a blend of practice and theory together. May I have the privilege of inviting the President of the National Industrial Council.
Thank you, Chair, for the kind words. Dr. Bani, the day before yesterday, you wanted me to talk at the cocktail. I said it was very noisy. I won't be able to say something. Yesterday, one of your people asked me whether I wanted to do a goodwill message. I said no. Can you please apply on my behalf to the chair to add the 10 minutes I have so that I can use up those periods? I think it is granted I have more than 10 minutes. I did a case involving an army officer. I awarded about 75 million, I think, which was not paid. He filed a garnish order, or he filed for a garnishing order myself, which I granted. And then the garnish was actually Central Bank of Nigeria. By the time Central Bank came into the fray to tell me that via the affidavit of course that they cannot pay, they first came by way of an objection, which I took and turned down. And then on the merit of the case, raised all kinds of arguments, including that because I am National Industrial Court judge, my enforcement of my judgment cannot be in National Industrial Court, it has to go to Federal High Court. It's a lawyer who was raising that, not me. I said, of course, Section 287 of the Constitution, Section 10 of the NIC Act, and indeed Section 54 of the NIC Act says I have the powers of the High Court, as confirmed by Justice Nweze, the Sky Bank and you. So I turned down. To cut a long story short, I granted the decree absolute, but because they said they had court of appeal, I said the money should be paid in an account with the CR of the court. Only for CBN to now file a motion for stay on the same grounds of the objection that I had done away with. And the day they moved the motion, the Judgment Debtors Council was in court. And I asked the Judgment Debtors Council, did you file any reaction to the CBN processes? He said no, which means automatically you don't have any problem with the order absolute. He said yes. And I turned around to the counsel of the CBN, what the hell is your business? As CBN, you hold somebody's money, that person says he has no problem with you holding the money or giving it out, and you are the one saying no, it should not be given out. What's your problem? What's in it for you? Go and put Central Bank of Nigeria on your law pavilion. You are going to see not less than 50 cases involving CBN as garnishing, rejecting garnishing orders. And the question is, CBN, this money is not your own. What's your business? But I worry because it is lawyers who file. Despite what the CBN said in the Stella, I showed the chair no less than 5 2022 cases at the Court of Appeal
involving CBN deciding differently whether CBN is a public officer or not. The cases I wrote down here in 8 pages. This is not a paper. I just brought the pages and then quoted where the statements were made in terms of those for and those against. So we have a system where, like Chief Ase Babalola would say, a party who has successfully obtained a final order or signed judgment against another has only won the first round of the fight. In fact, it's enforcement that starts your problem. And in approaching issues of enforcement, I want to quote Fidelis Odita, SN and QC, what is said about legal practice in Nigeria in Asaba, the section of legal practice. 1. Nigerian law is excessively and self-destructively procedural. 2. Our civil and criminal justice system is obsessed with form rather than substance. And 3. We take refuge in box ticking, formulas, and catchphrases instead of analysis. I want to talk about 3 critical issues here. One relates to Section 83 of the Sheriff and Civil Process Act. The other relates to Section 84 of the same Act. And the third one relates to Section 287 of the Constitution. Now, let me start with Section 287. I itemized 2 Court of Appeal decisions, CBN versus James HMB versus Osco Petroleum Limited is a 2018 decision. No, 3 actually. The third one is CBN versus Shipping Company Sarah BV is a 2015 decision. These 3 decisions say there is nothing unconstitutional about Section 84 of the Sheriff and Civil Process Act when you relate it to Section 287 of the Constitution. Now, the key words I want you to just have in mind in Section 287, whether it is the Supreme Court, whether it is the Court of Appeal, or the courts of first instance, it says that court shall, the decision of that court shall be enforced in any part of the Federation by all authorities and persons. Shall be enforced. Now, when Section 84 puts an impediment, these decisions describe that impediment as procedural. When you have a procedural impediment that disallows you from enjoying the benefits of your judgment, how can that be procedural? And you are dealing with that procedural element in a statutory enactment that is supposedly beneath the Constitution. In other words, the enjoyment of a constitutional provision is now being made subject to a normal statute. Secondly, Section 283 of the Sheriff and Civil Process Act. I'm not going to read out the section, but I just want to bring out a catchphrase just so that I can make the point I want to make. It talks about the person who is coming to file a garnishee application ex parte, what he needs to do. Aside from the affidavit, it must be sworn in by an applicant or his counsel. I have seen affidavits where it is a legislative clerk or a litigation officer who had sworn, and I had rejected it because the provision talks about the applicant himself or his legal practitioner swearing to the affidavit. But that is by the way. It says that the phrase I'm interested in is any other person is indebted to such debtor is within the state other than debts owing from such third person. Now, why am I bringing this? We have this practice of lawyers coming in and bringing 15 banks. I want a garnishing order NIC against these 15 banks. If you come to NIC by our rules, we are very specific. You must indicate the account number and the owner of the account if anybody is to listen to you. But I understand that other courts don't necessarily have that provision. So you have this ploy of listing out all banks. Luckily, Justice Afen in GTB versus Engineer Musa Pefi, that is a 2021 Court of Appeal decision, held that that practice of listing banks does not satisfy this provision. Because this provision talks about you getting somebody who is indebted. In other words, there has to be actual indebtedness. Now, if you don't have actual indebtedness, if it is speculative indebtedness, then it does not satisfy this requirement. And consequently, you cannot have any order made in your favor once you don't disclose the particulars of indebtedness, the account number, and the owner of the account. And now go to the more problematic section 84. That's the section that talks about consent. And the critical question is simple. Is CBN a public officer? Now, if you trace the historical trajectory of that, the answers to that question, it is traceable to Ibrahim versus Kaduna JSC. Ibrahim versus Kaduna JSC decided that artificial persons, artificial entities are persons for purposes of the Public Officers Protection Act. And because they are persons, they are so caught up. After that statement or that decision, the question then arose, is CBN a public officer for purposes of Section 84? And to my mind, erroneously, we it must also be covered as a public officer for purposes of Section 84. Now, if you look at the point, bringing the definition of a public officer for Public Officers Protection Act purposes and superimposing it in terms of Section 84 of the Sheriff and Civil Process Act. Then look at even the use of language in Section 84. I'll read two catchphrases. It talks about where money liable to be attached by garnishing proceedings is in the custody of or under the control of a public officer in his official capacity. The Interpretation Act says the masculine includes the feminine, but it never said it includes the neutral. So when Section 84 talks about a public officer in his official capacity, can CBN as an artificial entity qualify as his? Then you go downwards when it is defining appropriate officer in subsection 3.1. This is the language used. In this section, appropriate officer means in relation to money which is in the custody of a public officer who holds a public office. Can CBN be a public officer holding a public office? These are the words of the Act. If you read some of the cases, of course, an attempt has been made to rationalize. We don't want government waking up one morning and finding out that all this money has gone. The lead presenter alluded to some of these issues. In fact, I think it was Justice Idris in one of the cases, CBN versus Access Bank, a 2022 decision, who rationalized in these words: it would be absurd to interpret a public officer in Section 84 of the Sheriff and Civil Process Act in the restrictive sense as interpreted on the basis of Section 318 of the 1999 Constitution. Because if so done, the safety measures put in there for government funds would have been defeated. Government funds kept in the Central Bank of Nigeria are not kept with a particular individual who is a public officer. This is why the interpretation given to public officer in the case of Ibrahim as JSC, we are back to the same problem, by the Supreme Court should apply to all cases. How can an interpretation in relation to Public Officers Protection Act be said to apply in relation to Section 84 of the Sheriff and Civil Process Act? Just by way of, for us to understand the kind of problems we have, what Justice Afan would call theory deficit. I said, despite the CBN's decision in the Stella, we have Ecobank Nigeria PLC versus Africa Admiral Environmental Care is a 2021 decision of the Court of Appeal where they held that public officer, the CBN is not a public officer. You have CBN versus Triple C is a 2022 decision decided on 8 April 2022. You have CBN versus NX Merchant, a 2022 decision decided on 29 April 2022. You have CBN versus Markby Trading and Others, is a 2022 decision decided on 29 April 2022. You have CBN versus Kruger Brent, is a 2022 decision decided on 29 April 2022. You have CBN versus Elder Abel and Access Bank versus Mr. Ugochukwu, all one, the first one decided on 9th May, the second one on 2nd June. All these cases I listed held that CBN is not a public officer for purposes of Section 84. But the same Court of Appeal in CBN versus Access Bank is a 2022 decision decided on 10 March 2022. And CBN versus Abiodun or Sonoki, again a Court of Appeal 2022 decision decided on 3rd March 2022, all held that CBN is not a public officer for purposes of Section 84 of the Sheriff and Civil Process Act. Now the problem is this: if we go by the rule that says apply the most recent, I am a judge of a court of first instance. If today I am to apply this, of course the most recent is the June. The most recent is the June decision, which said CBN is not a public officer. But what it means is that if tomorrow another panel of the Court of Appeal decides differently, my colleague who may be deciding a case after me will have to apply that most recent decision, which calls to question whether the rule that says apply the most recent is actually a correct rule in itself. I come from the academics, and what we are taught in school is that all decisions are valid and subsistent so long as they've not been set aside. For you to set aside a decision, you should have referred to it and distinguished it and say why you are not applying it to form the basis, or even be very specific that you are now discarding it. So if as a judge of a court of first instance you give me two decisions that appear contradictory, I always tell my colleagues there's nothing you cannot rationalize. I look at what is before me. There are 1,001 instances in which I can distinguish the very fact that some provisions of law were not referred to, the very fact that some circumstances are not in the whole case but they are before you, are all distinguishing factors. This is how Justice Afren concludes a paper he wrote on the question whether CBN is a public officer. I crave your indulgence to just read it. He says the Sheriff and Civil Process Act, which entered into force on 1st June 1945 as an ordinance of the colonial administration, certainly did not contemplate, nor could it have contemplated the Treasury single account policy and the attendant consolidation of all inflows, payments and receipts from all agencies of government into a single account, or a set of linked accounts of the Central Bank of Nigeria, which makes the CBN a necessary party in the deluge of garnishing proceedings filed in the wake of the TSA policy. But as demonstrated, the definition of public officer in section 18 of the interpretation clearly excludes government bodies and institutions, including CBN, and the decision of the Supreme Court in CBN versus Interstellar Communications Limited is that the CBN, which acts as a banker to the federal government with respect to government funds in its custody pursuant to sections 2E and 36 of the Central Bank of Nigeria Act, does not stand as a public officer in this situation. And no necessity arises to seek the consent of the Attorney General as a precondition for initiating garnishing proceedings against the CBN. It would seem therefore that the answer to the question posed in the caption of this chapter is necessarily in there negative. In conclusion, I want to highlight some practical problems we are facing. If you go to our main headquarters, the new one we are building, behind it you'll see one old, I don't know what they call it, it's a road caterpillar, those heavy duty caterpillars and so on. It's been there before I took over. When I took over, I asked, what is that thing doing there? I was told they brought it there as an attachment. A lawyer had filed to attach it to a judgment. Now it's been abandoned in our premises. I don't know the lawyer who applied it. I don't know under what circumstances it was applied. But I have the headache now of disposing something that should not have been there in the first place. The administrative judge in Abuja, some few months ago, wrote to me a letter itemizing attached properties that were now dilapidated, vehicles that were now down, and it's like lawyers rush to file for attachment without taking into account the state of the properties they are attaching. I don't know whether you have ever heard of this story. They said a Nigerian in the US, New York to be very specific, had a very expensive vehicle. And he calculated, he wanted to park it and travel, but the cost of parking was so high. So he walked into a bank and said, please, can you give me a loan of $5,000? And they said, well, we can give you if you can bring a property of value. And he brought the car. So they took the car and kept it, gave him the loan of $5,000, and he traveled. After 2 weeks, he came back and repaid the $5,000 with interest and took his car. And by way of curiosity, the banker was like, how can you have this kind of costly car and you're coming to take a loan of $5,000? And he said, where else can I park a car in New York and pay such a low amount of money? Why am I bringing this story? Sometimes it's like lawyers, to seem to be doing something, attach properties of little or no value just so that they can have court premises to park them. They are becoming an eyesore. In fact, at the meeting of judges of the court, I intend to present the issue on the table, just so that we can find out whether to begin to start refusing to award such attachment orders, because they are really creating an eyesore. How we are going to solve it, I really don't know. But the reality on ground is that the place is littered with attached properties that are now of little or no value. Thank you.
Chairman, sir, permit me to stand on existing problem. The shoe I'm wearing this morning is too big for me, because I'm wearing the shoe of the president-elect, and who at the time he was at the computer panel doing all the law. It was those things that lured us into becoming lawyers. So I will try today to comment on the paper as best as I can. All the ones that I say correctly is the president-elect that says so. Anyone that I say in error is my error, please. Thank you very much, Akapa Bidividi, for the paper. I think as practitioners, our problem became dire with the single treasury account, because now all enforcement against the government since the operation of the single treasury account has come to almost a position of halt. If you go to the Ministry of Justice, you'll find that you hardly ever get consent to enforce judgment. And as my Lord the President did say, the decisions coming from both the High Court and the Court of Appeal are not in any way settled. They are confusingly numerous that a lawyer cannot have a solution to this problem. When the Supreme Court decided the case of Central Bank of Nigeria against Interstellar Communications Limited, 2017 Law Pavilion Electronic Law Report, we thought it would be Uhuru. If you recall, in that case, there was a judgment get against the then NIGER. An intergovernmental committee was set for the payment of the judgment debt. In the course of the execution, as part of the membership of the committee, the Office of the Attorney General of the Federation was included. he had issued advice that part of the payments be made. But somewhere along the line, the government refused to pay. And garnishing proceedings were initiated in 2012 against the Central Bank of Nigeria for the payment of the balance. The issue that came up in that case was whether you need to obtain another consent from the Honorable, the Attorney General of the Federation before that judgment could be enforced. The Supreme Court made two very wonderful pronouncements in that case. First, it said that because the Attorney General, by conduct, having commenced the payment of a part of the judgment debt, is deemed to have given consent. Also in that case, just as rightly as my Lord the President did say, the Supreme Court did query the Central Bank of Nigeria to say, what is your business? You are, for purposes of these proceedings, just like any other banker, you are a banker of the government, and every time there is such a judgment there, your own is to act as a garnishee, disclose whether or not there is a debt, and pay the money. But of course, our dilemma is not about the presence of the law. Our dilemma is our success in refusing to follow the law without consequence. Because in advanced crimes, no lawyer will touch any other thing. Say maybe you are representing CBN as garnish. After that kind of judgment, come and say you are bringing another preliminary objection, challenging jurisdiction, or you're bringing motion for stay. You will be sanctioned by the bar, by the disciplinary committee. You will be sanctioned. The cases are everywhere in England, America, in Canada. If you try it, you will be sanctioned. I think it is high time that for all of these people putting obstacle in the enforcement of judgment by bringing repeatedly objections that have been frowned upon by the Supreme Court in previous judgment should not only be, overruled and then we stop there. I think we should go a step further by referring them to the Legal Practitioners Disciplinary Committee. I have had at least two proceedings where a lawyer brought a frivolous proceedings, an application in the case I am conducting, and before we commenced, I told the court that in responding I am making two applications. First is that if the court upholds my response, then the court should refer that particular proceedings to the disciplinary committee so that persons, if the disciplinary committee finds that there is a misconduct on the side of the counsel, he should be sanctioned. In those two proceedings, the lawyer will do the applications. I think that is the things that as legal practitioners should adopt, so that if any of such frivolous applications are brought, you are able to get people to withdraw because the professional regulations are very clear about them. Next is the headache we are facing with the Honorable Attorney Generals. In Onjepo against the State Ministry of Commerce and Industry, cited in the newspapers, in the Speaker's paper, the Court of Appeal did say that there is no Attorney General what he sought that should refuse to give consent for the enforcement of money debt against the government. But are the Attorney Generals what they sought? The jury is out. Now, the next problem we have is the problems of the courts. Oftentimes, my Lord, and I'm very sorry, courts will come and say, oh, they do not respect our orders. People don't give any, people don't consider judgments of court. Say, is it not judgment of court? No problem. The first question I want to ask is, the judgment is an appeal against the judgment of a court a stay? The answer is no. why are justices or why are the trial courts reluctant in granting execution of judgment, particularly garnishing proceedings? Because it has been said that garnishing proceedings does not form part of enforcement of judgment, isn't it? So why would we not continue with garnishing proceedings merely because a judgment debtor comes with a notice of appeal, which he has no intention to pursue? Why do we do that? In fact, the most disheartening situation is in respect to contempt proceedings. You know you're from 48. You know that if you do not photocopy the order of the court on the back page of the Form 48 and you take it like that till the end, a judge sitting will say that you have not properly initiated contempt proceedings against a contemnor who has in fact been served that Form 48 and Form 49. Why should these contempt proceedings be defeated by technicality? Of all the contempt proceedings that have been initiated, all of them have been defeated on the ground of technicality. In fact, a defendant will even come to court and say, my lord, it's not that I'm not aware, it's that the judgment, the Form 48 or Form 49 was served, it was not properly photocopied. So we have to, the courts themselves must show a readiness to enforce their judgment and not allow technicality be the reason why people will disrespect the court. Finally, my lord, semi-final, I'm sorry. And I'm very sorry, I'll finish just now. Now, there's this issue that my lord the president did raise, and it's of course a very serious concern, and that is the issue of speculative garnishing proceedings, particularly those against banks. Yes, it is true. We have a big problem in determining whether people have monies in account. First problem is that there is no bank that is going to disclose to a judgment creditor that a judgment debtor has an amount standing to his credit in the account. No. That those banks are protected by the duty of secrecy which they owe to their clients. Now, how then do you enforce judgment? Because you see that this becomes a very big impediment. My lord, the process I have been watching in other courts is that oftentimes when you come with this speculative application, because it is an application to show cause, the banks where monies are held do in fact come to disclose. And in circumstances where there are no monies, they come and say there is no money. I think, my lord, we should try and assist a judgment creditor by allowing this speculative process to commence, because being an order to show cause, no right has been, no debilitating order has been made against a garnishing at the time, so that we don't have a situation where I have judgment debtor has monies in several banks, but I cannot enforce because I cannot determine the account number, and I cannot enforce because I cannot tell whether or not the money is standing to the credit of the cost of the judgment debtor. So I think this is something we should look at, so that we try and assist in the oiling of the wheel of justice. Then Akapa Vigiligi did introduce a very interesting position. Deputy sheriffs are not sufficient to enforce all the judgments that are being dished out in Nigeria. So I agree that private judgment enforcers should be considered in enforcing judgments. However, we should be careful, because when you give a private enforcer, he shouldn't go beyond his remit, so that we don't go back to the same situation where which is condemned in Ojuku against Federal Republic at Governor of Lagos State, that amounts to self-help. Thank you very much.
Very well done. Thank you very much. And finally, the last and not the least is our cerebral young SAN, ex-wild Secretary General of the Nigerian Bar Association, a barman to the call, Afam Osiri SAN.
It's so difficult speaking after such evident men and being the last to speak. You get the impression that everything that needs to be said has been said. But nonetheless, since I've been a member of this panel, I will do my best to make some contribution. The topic for discussion this morning is impediment to seamless execution of court judgment. Let me start by saying that my Honorable Justice Kanyip, the President of the National Industrial Court, said a whole lot without calling it by his name, so I'll try to call it by his name. My Lord is simply saying that the major problem to enforce seamless enforcement of judgment is judicial inconsistency and is self-inflicted. The judiciary importing wrong things into the law to frustrate enforcement of judgment. We must call it by its name. A situation where you have recurring inconsistent judgments from the Court of Appeal. My Lord cited within the space of a few months, so many inconsistent judgments. And yet you are asked to take that when there are many conflicting judgments from an appellate court, to take the most recent. So despite the wrongness of a decision, a court of first instance is asked to apply a very wrong decision. Now, it's not only the Court of Appeal, it's in the Supreme Court. After a CBN and a Interstellar was delivered, we were very excited that finally a judgment had come to judgment. But when we sat down to read the judgment, we know that the case created more problems. In the lead judgment of Honorable Justice Ogunbi, in one breath, the judgment says that the CBN acting as a bank at the federal government is not different from a commercial bank. In other words, showing the bank of pure technical services and in Lagos State. In another place, forget that the consent of the Attorney General was very important. The court was not definitive. So you see in an appeal, two parties, opposing parties relying on the same judgment. And when I say judicial attitude in front of the impediment, self-inflicted, if section 287 has said that judgments of the Supreme Court of Appeal and Court of First Instance shall be enforced by all persons and authorities, and the Court of Appeal in several cases decide that section 84, which brings a stricture to the exercise of the power to enforce judgment, is procedural and therefore not constitutional. We can only cry that someday we wake up to realize that we are wounding ourselves, because what makes a court important is the confidence the public has that when you get judgment, you'll be able to enforce it. So I met a man last year who alleged that he had been brutalized by the police. And he told me his story, and I suggested going to court to enforce his fundamental rights. He said there's no need to waste time, I have left it in the hands of God. That his friend who had a similar situation, suffered a similar fate, was awarded 5 million naira many years ago and could not get that money. Like they want to waste money paying lawyers, getting judgments that he will not be able to realize. And another problem we have is also the law. Section 294 says that every court shall immediately after the completion of judgment within 7 days make their decision available to the parties. Here, 1 month after you are told that my lord is still reading it, they are typing it, judgment is not ready, go and apply. And my reading of section 294 does not suggest that you have to apply. It seems to be a duty put on the court to give you this judgment. But they say, where is the application? You have not applied. They are proofreading it. They have not certified it. They are typing it. My lord is not allowed to sign it. And you cannot enforce this judgment, whatever award they are giving, without getting the judgment. And I'll give also another extreme example of judicial inconsistency. If you read the case of Owena Bank, Olatunji and Owena Bank, in that case, Supreme Court, Minister for GSC said that a monetary judgment immediately made by the court is enforceable, except the court has declared otherwise. Last year, the judge was suspended for signing a writ of 5-5. Yes, the Supreme Court. Let me give the citation of the case so that we can all read it if you have it. Sorry, just a moment. That's the Olatunji Owena Bank is reported in 2008, 8th Nigerian Criminal Law Report, part 1090. Yeah, they say it is a monetary judgment that under 4, 1, 2 or something of the judgment report does not apply to it. Yet, today, the judge is afraid of signing the writ of 5. So I will tell you, you have to wait for the 90-day period of appeal before you can enforce. Nothing says you cannot really enforce. Now, I will also say fraud in the enforcement unit of court. My Lord, when my Lordship spoke, the Lordship talked about people taking things that are not brought up in judgment day. What happens in reality is that people in the enforcement unit, I wish I could call them criminals for that time. So you take a vehicle in execution, and the next thing they say they have to evaluate. Sometimes they leave the doors open, the bonnet open so that the rain will hit it. Then they evaluate it as a dilapidated car. And then you see some of them driving those vehicles out. The law requires that the auction sale be made public. You never see that publication. They paste it and remove it. And then if people turn out on that day, they will tell you that the execution, then the sale auction has been postponed. Then you come back another day and say, oh, the auction has taken place. Fraud in the enforcement unit of court. So sometimes they will keep the regarding, they will not take a decision, they say, but we don't even know who these auctioneers are. And then sometimes they say, this is the reserve price, or this is how much you give, so that you can buy it. So it becomes a negotiation. And then sometimes when council applies, that the council be allowed to sell the item taken in execution by private arrangement, so that the judgment creditor will get more benefit. Some courts will refuse to permit it, even though the judgment enforcement is still by private arrangement. Now, another problem in impediment is that, for example, in the Abuja, it must apply to chief register. So your application can remain on that desk for weeks without any action being taken on it. Now, I want to leave the law a little bit. Then the involvement of police officers is another big problem. So they tell you have to apply to the commissioner of police. You have to pay money. And if it is against government, they will never pay. And then some places they go. Now in the US, they have what they call United States Marshal Service, USMS, created by the Judiciary Act of 1789, which makes them the armed unit of the court. They provide protection to the judges. Now, DSSI provides security to advance and police. You don't know whether they are spying on them or providing them with security. The court should be able to have its own security personnel, enforce judgment, and even take custody of persons when they are within the court premises for trial. The marshal service should be created by an act of the National Assembly, because Item 57 gives the National Assembly power to make laws for enforcement of judgment, which by the way I disagree with Chief Ozekomi. The issue of enforcement of judgment is not a public debt. Public debt refers to when the public government borrows and is owing the public or contractor. When a debt arises as a result of judgment pronounced by a court, it does not qualify as a public debt solicitor. It falls under enforcement of judgment, which the National Assembly has made the Sheriff and Civil Processes Apportion to Item 57 of the exclusive legislative list. So it does not qualify as a public debt say. It falls for enforcement. And allowing the Attorney General to have a say also over enforcement means that the judiciary is throwing away power. He's making an Attorney General a supervisory authority over 5 institutions of court. And any court that yields judicial power to exercise of executive power by Attorney General scores an own goal and deserves no pity. Now, finally, before I sit down, Sometimes because it's a sitting judgment, somebody sits down and gives you a huge cost that sometimes does not make sense if the amount is not much. Final reason is a slow appellate process. Some persons, you get the judgment, they know that they are barely filing an appeal by the Supreme Court and filing a motion to say that for 10 years they may get it free. And they know that even sometimes when the decisions that get on the NIC stops at the court of appeal, they put an appeal at the Supreme Court. After I've talked about the time process, to what extent do our courts refer practitioners to their LGBTQ political action for putting the legal process in the wrong way? We must set example. We must do the right thing. We must ensure that right persons are appointed to the bench who will interpret the law positively and not interpret the law so as to weaken the court, to ensure that when judgments are given, people will be able to reap the benefits of their judgments. Thank you so very much for that.
Thank you very much. I have been told that he's not the last speaker by the Secretariat, and that we're going to have online the former chairman of SPIDEL, Dr. Paul and another SAN. And I call on the Secretariat to please hook us up to Dr. Paul and another SAN to present this speech. From the other end. So we start from the right hand side. Then I have two questions. If there's any. Yes? Please can you give him the microphone? Please make it very, very short. If it's a comment, say so. Step down forward. It's taking some time, so we can save time because we are supposed to end. Come down forward.
The chair, can you hear me? Hello?
Dr. Nanaba is here now. So, gentlemen, please, if you can wait on the front row so that you don't go back and we look for you again.
Let me begin by thanking the chair, thanking my elder brothers, Michael Dr. and Afamosikwe and Learned Justice Professor Kanyip. Professor Kanyip was just inspiring many years back. He's been there, erudite as always.
and the representative of the president. When I've listened to the presentations, and we can go on with the countless woes that the devil enforcement of judgment, execution of judgments in Nigeria is so pathetic, and all the points have been made. I just hope it's not another workshop where we talk Capo, not much done about them. If a party goes and judgment is given or orders are made, I cannot. It is one of the things that is fueling violence in the country. When people lose confidence in the enforcement and execution of judgment, they begin to resort to self-help. So it's important that we know that enforcement of judgment and execution of judgment is so important. It must be seamless. It must be seamless as the word seamless is, so that people know that yes, judiciary is actually the group of government. My intervention will be much more on another area of judgment. Judgment. We've been talking about judgment delivered by the courts in Nigeria and all that's made by the courts in Nigeria. You will recall our experience in this country where we see public officers, lawyers in the Ministry of Justice saying they will that judgments will not be obeyed or orders will not be carried out. Fight is given, opinion is given, and that. My focus will be on foreign judgments. Because I also talk of judgment of time, we have deeper problems even in foreign judgments. So I want to bring that up a lot. Listen to our previous speakers. Speak on international judgments, and not much needs to be spoken about it when you take away section 54, look at international law, look at the bailiffs obtaining the receipt of judgment, and again going to the police to get the police into enforcement and all that without actually an enforcement, total enforcement mechanism in the console. Foreign judgments are another area where enforcement has become a problem. As early as 1922, there was the spoken judgment. I tell you, as we speak today, it is still that 1922 audit that practice the applicable law to enforce judgments that are informed, that are delivered in 2022. 100 days away. And you will now see that it is difficult for that to take place. Now, we should be aware of the case of Macaulay and because as well, the 1958 Investment Development Act, so what we kept putting together in the compilation of the laws up to 2004 are just not unapplicable laws. So what is the problem with the Section 3 of that Foreign Government Act, which you have from 1961 to 2004, but the general must extend responsibility to countries before such we can import judgments from those countries. And I can tell you, the Nigerians have existed, no attorney general has done that. But that any foreign judgment is practically unenforceable in Nigeria. In fact, Section 2 of both the 1952 ordinance and the 1958 ethnic system ban 2004, all of them say that even a foreign judgment can award, so technically speaking, you can enforce a foreign award in Nigeria. So, how do we make this situation become seamless? I have published a work on this, and it's in the public domain. I have propounded an essay and debate which I tried qualified topics, because the theory of coming trade and begin qualified comics in which the court proceeds from the committee. When it gets to the problems of the committee, the court has jurisdiction under Section 6 to do justice in every matter. I give you an example. In Ghana, and the Greek refugees were short of women in that particular case. In Nigerian places, products gets benefit, pays by kid advances, refuses, run back from England to Nigeria, and this of means of education. The judgment is not in England, came to enforce it in Nigeria. The Nigerians say, well, or we have our trained English. And this is where I was living about it. And we cannot be allowing this to happen. But that is where I stop. That the guy has not done anything to today. I don't know whether one will want this. No reciprocity. And reciprocity has become a huge problem to see. But Nigeria funds so much of people give them accommodation and all that. If they go towards not judgment, are not even important in Nigeria. Once you leave, particularly when it is against whether the government or anything, you still I took interest in Professor Kanyip's presentation about how many cases involving CBN. I think the CBN should review their approach to their issues. In one such case, the CBN brought preliminary objection that the judgment of ECOWAS has not been investigated and the consent of the Tanzania has not been obtained. In this year and age, no. Because the ECOWAS from its treaty is a supranational court. And by the Vienna Convention country,
Dr. Thank you so much for your contribution. The time is up. We realize that the main focus of discussion is on enforcement of foreign judgment. I will take your contribution into consideration. You related it to not just the foreign judgments that come from the Western world. You're also talking about that of ECOWAS. Taking all that you said into consideration, and it will be properly analyzed by the audience. And we're enjoying you to continue with us. I'm so sorry. The next session starts at 12, and we want them to ask as many questions as possible. Thank you very much. Question time. The gentleman that is on the right, can you come to the group because there's no feedback.
Solomon Yahya. I'm from NBA-SPIDEL. So if you give me a round of applause, we will take the risk to come my question, the last discussant made attempt to answer my first question, which is on whether the judgment gotten in Nigeria can be enforced outside of the country. Because recently we got a judgment in NIC in Kaduna, and before the government debtor, while he was a defendant, realized that the case was actually going against him. So when he entered the defense, before final addresses and judgment, he left Nigeria, cleared all his money in all the banks, and he has been in South Africa since then. What can we do now to enforce this judgment, or are they enforceable? As one. My other one is an application to my Lord, the President of the National Investment Court, if he could apply for the lady's paper available to us. The paper probably will be rich and very helpful to some of us young lawyers. So we apply to my Lord to make the paper available. Thank you.
Secretary, thank you. Any other question? My right hand side? Yes. Stop to me.
Is that the last chair? Would that be the last?
We answer at once.
Okay.
Very grateful, my Lord, all protocol duly observed. Mine is the respect of the chief proceeding, especially when the judgment is handed down. And most of our banks now, when the order nicely is handed down, before the order absolute, most of the time, the judgment debtor will connect with the bank and transfer that money elsewhere, so that the absolute, when they find there are affidavits disclosing the fact they will get certain amount, which is very minimal, while the huge amount has been transferred elsewhere. So this connection with the bank and judgment debtor, how can it be tackled? That's my question. Thank you very much.
Thank you. From the middle, please give him the mic.
My name is Adekunle Shobalu from Ibadan branch. I want to thank Honorable Justice Kanyip for the thorough and in-depth analysis of Section 83 and 84 of the Sheriff and Civil Process Act, which deals with enforcement of the judicial proceedings. My question, based on practical experience, is whether a company to whom a judgment debtor transferred all his monies and assets in order to evade the judgment of the court, can be held to be a person to whom the judgment debtor is indebted to under Section 83 of the Sheriff and Civil Process Act. My second, which government has to do with suggestion. I noted that the keynote speaker and all the discussants admirably identified the problems with enforcement of judgment in this country, but did not dwell much on the way to find solutions to these problems. By way of my own contribution, I want to suggest that in order to avoid the frustration of enforcement of judgment, we should amend our judgment enforcement rules to make it a condition for any judgment debtor that intends to appeal against a monetary judgment to give or issue in favor of the judgment creditor a bank guarantee immediately redeemable on his or her failure to perfect the conditions of appeal. With this, I think there will be a bit of a solution to the delay in the enforcement of judgments in this country. Thank you.
Thank you very much. Any other? Lady speak today.
Good morning, Chairman. The Lion Sound. My name is Richard Olusegun. My question is this. Since Section 84 of the Civil and Civil Process Act requires that consent of the Attorney General must be obtained in enforcement of judgment when the body is in the custody of the public officer. In the event the Attorney General refuses consent, is it possible for someone that wants to enforce judgment to revert to the court and apply for an order of mandamus against the AGM? Will the court grant it? My second question is directed to the Lane Sir. That is Ozebo. Sir, you talk about advertising enforcement of judgment. You talk about advertising enforcement of judgment. Sir, how possible it is when in this present situation we are now, judgment cannot be enforced against security personnel, especially the Nigerian Army. If we now have a private enforcer, how possible will it be for them to enforce judgment against the Nigerian Army? That's my question. Thank you very much.
My name is Ronald Otaro, SNP. My colleagues, those talks, even foreign courts have even given judgments in 1975 that the Central Bank of Nigeria is neither a ministry or a department of the federal government of Nigeria. But Chairman, sir, that was the case of changes Nigerian newspaper of CPN. 1975 one Nigerian law report. And that decision was given by the Court of Appeal in England by Lord Denny out of the road when he came down from the House of Lords to sit at the Court of Appeal. The problem we have in Nigeria with the greatest respect is conflicting judgments, especially of the Court of Appeal. And as they have regard to the very erroneous decision in CBN matters interstellar, that decision should have put pay to any decision of the Court of Appeal in relation to the enforcement of judgment that is having to get the consent of the Attorney General of the Federation. Apart from that, I want to make this comment very lucidly, that is, when you release banks, you can receive procedure. I think it's the right thing to do. In Lagos State, when you want to enforce the judgment by way of the proceedings, you list all the banks in the country. Anyone that does not have the account of the judgment debtor will file an affidavit to show cause that, oh, we have to use some of money. I, with the greatest respect to the president of the National Agricultural Court, very cerebral Judex, I want to sell this advice without a payment that I think the National Agricultural Court should also look inward so that if a certain judgment to be executed by way of penalty proceedings, the judgment creditors should not be subjected to looking for their land of the judgment letter. I think it is better. The reason why I said it is that if you are now looking for the account number of the judgment letter, then the court itself is making the judgment not to be effective. But by giving opportunity to the judgment creditor to release the bank, you are giving efficacy to the enforcement of your judgment. I think that would be the way forward. Thank you.
Thank you so much.
Thank you very much. My name is Abdullah Garai from NBA-SPIDEL branch, Kanyip State. I have a question to my Lord, the President of the NICN. And this is regarding what my Lord earlier said, regarding conflicting judgments of the Court of Appeal. And my Lord advised that although there is a problem with going with the latest judgment, because it can change anytime, that judges or courts will try to rationalize the decisions, the conflicting decisions, and civic suits or first suits the case at hand. Now, my Lord, I'm happy my Lord agrees that perhaps it is not very credible to say that the latest judgment of the Court of Appeal should be followed. Because that means the Court of Appeal has the power to overrule itself, which it does not. The only court in Nigeria actually which has the power to overrule itself is the Supreme Court. That is why the Supreme Court gives the judgment today, and tomorrow gives a different one, then it is the latest one that should be followed, because the court has the power to overrule itself. Now, the Court of Appeal does not have that power. So perhaps, my Lord, what do you think that, since that is the case, the first case that the Court of Appeal gave on that issue is actually the law. Any subsequent one perhaps will not be able to overrule the earlier one. So on this issue of whether the CBN is public officer or not, perhaps it is the first decision that the Court of Appeal gave that's actually the valid one. But I want to know what my Lord thinks about this. Thank you very much.
Thank you very much. This is the last question, I'm afraid, and I'll give the discussion 1.5 minutes each to answer the respective questions posed to them. I will start with my Lord, the President of the staff.
Thank you, Chair. Let me start with the last question regarding conflicting judgments. The point I'm trying to make is that if you look carefully at the judgments, you will find distinguishing factors that make one or the other not applicable to what is before you in terms of justice of the case. The question whether the very first one is the correct one cannot really stand. If you look at it relative to Section 84 of the Sheriff and Civil Process Act, which we are discussing, I drew attention to the wordings of Section 84. Did any of these Court of Appeal cases look at the wordings? Did any case, for instance, decide the his that is used in Section 84 refers to who or is referable to who? Was the Interpretation Act considered? I started off by giving the context in which I made my own intervention. The question that CBN is a public officer is traceable to Ibrahim versus JSA Kaduna. And in that case, what was the issue of whether an artificial person qualifies as a person in order to have the Public Officers Protection Act applied to him. That decision did not even define public officer. So why would subsequent cases take reasoning from that? As far as I'm concerned, is a faulty foundation having to make that reference. So you still have to come back to the wordings of Section 84 and then look at the cases before you. I made the example about the most recent, just to show how illogical it can be. And the paper I had, like I said, is just a
retinue of cases, and I deliberately put the cases and the date they were decided. You will find out that some cases were decided about 3, 4 on the same day. Now, if you say apply the most recent, the illogicality of it is that if a decision today says CBN is a public officer, and a decision tomorrow says CBN is not a public officer, you who is applying will take that of tomorrow. And so long as they keep oscillating, that's how you too will keep oscillating. And this theory about a court cannot overrule itself, I don't know where people got that thing from. What we were taught, and here I come like an academician, is that courts of coordinate jurisdiction cannot bind each other. What they decide is persuasive. But the point is this: if you say I am not following A because it's a court of coordinate jurisdiction, you must say why. You are not following. You don't just say because he's court of coordinate jurisdiction, I won't follow. The duty is for you as a judge to say why you are not following. It is that why that will then determine whether you are right or wrong. So that when an appellate court sits over your own decision, it will then say, look, as between these two, we either agree with you or we don't. The whole point I'm trying to make is simple. Those of us who are duty bound to advocate are not putting enough analysis into these issues, and that's why we are creating more confusion. There is a bit of laziness on our part. But of course, if you look at the practicability of some of these things, when you sit down and you see a court of appeal judge giving 20 cases to write judgment for, you ask yourself, how can he put his best into it? I remember, I think it was the Chief Justice of Ghana who said the Supreme Court in Ghana sits only once a week. And we said why? He said because the Supreme Court justice needs time to think. Now when you sit down and you carry 20 judgments, and don't forget, it's only in Nigeria where the constitution says you must deliver a judgment within 3 months. I'm not sure elsewhere they are giving that kind of constitutional blockage. There is a case, those of you who are interested in labor matters, the question whether Uber drivers are workers. The Supreme Court of UK took arguments in July of 2020. The judgment on that was given in February 2021, 7 months after. But in our own case, we give a Supreme Court 90 days to deliver judgment. Only in Nigeria you have that kind of thing. Issues were raised on the speculativeness of having to list all banks. If you do a little bit of cost-benefit analysis, let's assume you listed 20 banks. I attended a conference where the bankers complained that the list they pay, you go and say he does not have an account with us, it's 150,000. The list they pay. I don't know, I've never charged, so I don't know whether they are talking true or not. But let's assume we listed 20 banks and only one has. On a cost benefit analysis, it means 19 banks are going to pay 150,000 for coming to say he does not have an account. But that's even by the way. The case I did involving the army officer. The army officer was able to get the army's account number in CBN. What point am I trying to make? A lawyer cannot sit in the comfort of his office and expect that people will do research and bring for him, or he has a shortcut way to be able to get. If you go elsewhere, lawyers have what is called private investigators. When they have naughty issues and they need to get facts, they contract private investigators who get the facts. Talking about getting an account number from a bank, I'm not too sure it's a difficult thing. Because a minute. Because all you need to do is try to pay 1,000 naira to that outfit and the account number will come out. The account number will come out. So the argument that you cannot get the account number, for me, is not, it's a very weak argument. Because if you really want to get the account number, in any event, tell the judgment debtor, I need this account number and see whether he will not bring it out.
We have come to the end of the program. I'm so sorry. I can see my translated and people want to ask more questions from more minds. I will advocate that all questions you have, you can put into the NDA and it will be taken into consideration. But we can say, I want to say that before I get to your participants, that a lot of improvements have been highlighted. More important as it relates to court officials. We have seen that some of our laws are close to people, which court officials exploit one way or the other, and there is no provision for their punishment as of today. In other words, the court officials for your business that are much more than the judgment there. And just have to look at the judgment for in giving the demand. We have also seen the outcome of using state of execution in order to postpone judgment enforcement. And like it happens in Britain, sometimes the judges will be sent to direction and you may see that you should be aware that if you're making a divorce application, you have to pay for it. My left friend on the USA has tried and submitted, but if that is not a part of our law. So this is part of our law that where you make such the body and compensation by the law and Zambia for the JD and if at the end of the day, the activity of no water and becomes a frivolous application that the excessive amount. With that, I'm sure that we will continue the use of fee or execution frivolous. Now again, we have punishment also for the past, and also the court officials in collusion with the past. We should argue for that because the banks, by the time you get the other license or after the other license before you go to absolute, the court officials will inform the judgment debtor and he transfers all the assets outside jurisdiction, and by the time the revenue has gone to come down to the next share and the company you can do. Meanwhile, the court officials join whatever they are doing for the judgment debtor and the judgment debtor's mind will go because it's not the fact that is behind the judgment debtor to reap the fruits of his labor. We have also identified the capital law, the Federal License Section 84. Do we really need a consent of that law in general? Do we really sincerely? If we are talking about this capital law, it can be looked at from different angles from my own perspective. In the first instance, is that we are asking for its abolishment. The Attorney General should not be sitting in judgments against judgments of courts of justice. And it is not his duty to deny consent for the enforcement of a court's order. I think if it really read notices that Attorney General, just notify him, probably for notice, let it be notify him, but not his consent. Giving him consent to do otherwise would amount to making him an advocate in the court. But better than that, we have also seen a lawyer here still advocate from experience of what the law allows to function and now we will deny it in court. We have also heard about the enforcement of judgments gotten from outside the country, and somebody asked also whether a judgment successfully well. And for judgments that are coming into Nigeria, once you register, you can enforce. But there is also an exception to the general. One has to do with jurisdiction. If the original court that is the judgment does not have the jurisdiction to do so, then it can be questioned in Nigeria. And if it's against public policy in Nigeria, it can also be questioned in government. I've had one personally that is on matrimonial courses, and the gentleman participated in Britain in relation to the action, and somehow the PC was not there, maybe the judgment was for court has no jurisdiction. At the end of the day, the court in Nigeria is done and said, I understand you are not waiting for me to run, but I just want to summarize because I don't say from my answer some of the words. So I'm just bringing to them some of the answers that really are dictating the minds of the audience that you do not have the privilege to answer. So being that as a teacher, I want to profess a three-pronged suggestion. One is has to do with our case law. And according to our case law, we pray that the application of the judiciary that there should be a reconciliation of the views, more particularly from the Supreme Court, so that the judgment of state is like we should have to a person. And then secondly, statutory provision. We need an overhaul, a restructure of our enforcement statutory. And finally, the Chief Executive suggested the setting up of private marshal. I would say there should be an independent executive regulatory body. The provisions that will be statutory overhaul of the system, we should be able to curb the nuances of court officials and judgment they talk by criminalizing some of the activities where they are supposed to be and we are taking punishments to them. And then the case law, I just wish to mention specifically the one I did not like some of the senior Stella in the sense that he went to Supreme Court or Mumbi said yes. She and therefore, Attorney General will be should be considered to have given the notice. So, gentlemen, at the end of this, I think that the FBA has a part to play. Harness all these judicial divergent opinions and then have it with the judiciary and we resolve it once and for all. Thank you for listening and
Thank you. You know, I wonder, you see, this is really what happens when you have what they call the timber and the caliber in terms of intellectual capabilities and depth of experience in that field. One more time, I really want you to appreciate the chair of the session and the lead presenter and the panelists. But you know, just like yesterday, I am not qualified to stand and thank you. So I'm going to call the chair of SPIDEL, I'm going to call the vice chair of SPIDEL, I'm going to call the secretary of SPIDEL and the chair of the local organizing committee to come and do the needful, to just on behalf of SPIDEL, tell these panelists and the able chair and the able lead presenter, thank you in the SPIDEL way. Thank you again. Please, I encourage you. Thank you.
Thank you. Thank you very much. I want to appreciate all of you once again who are here for the second day of this wonderful conference. And of course, the panelists made up of heavyweights. Madam Asinge, Senior Advocate of Nigeria, has already got her tickets to travel, but I have to take struggle with my request that he has to be here to share this particular panel. And she acknowledged us. Please, once again, can we give her a round of applause? She has done it so well. She has displayed her skill, her knowledge, her intellect as the panel chair. Madam, we appreciate you. I want to appreciate my Lord, Honorable Justice Kanyip, PhD. It's important to mention that. He came from the academic background, and he also has been a practitioner, and now a judge. You can see the combination of what he has actually displayed this morning with all that knowledge about this issue of impediment to seamless execution of order. Once again, can we appreciate Honorable Justice Kanyip? Remember that he gave us a very short cocktail on the 3rd of this month. Lord, thank you. We appreciate you. You remain a member of SPIDEL. My honor to talk about Chief Mike Ozokweme, Senior Advocate of Nigeria. He's a great man. He's a great man. Prof, once again, you couldn't travel. Madam is abroad. You are here for us. We appreciate you so much. Ladies and gentlemen, let's appreciate the chief himself, high chief, the lover of Ndigo. That's what I call him. He loves Ndigo so much. Please, God bless you. After Mosigo, we can't do without you. You've always been there for us. A brilliant lawyer. A brilliant lawyer. He's a intellectual lawyer. And of course, he's very us on this morning. Thank you for your knowledge on section 84. Because who represents our incoming president is this great man. Before you did well. You did well. We appreciate you. I think you are the one that got to be presented in the program that happened in Abuja here this week. I saw you on television. You are doing well. Thank you very much. Please, it's our honor and privilege to now hand over our gift. SPIDEL wants to give them gift. And so the first person is Madam Dr. Mrs. Valerie Yazinge, Senior Advocate of Nigeria. If you want to clap, don't press it to clap. Clap. Valerie, you are grateful. You are grateful. Thank you very much. God bless you. Who else? My Lord. Okay, Chief Mike Ozokweme, Senior Advocate of Nigeria. Please appreciate Eze Bulbulu. Thank you. I appreciate you so much. God bless you too. Thank you. Thank you. How far to see with the eminent lawyer? That's why it's secretary. Thank you for your contribution. Highly intellectual. We appreciate you. God bless you. Thank you. Who else? Thank you. You are giving me a round of applause. Thank you very much. Okay, Milord is your turn. Honorable Justice P.B. Kanyip, PhD. I wanted to put you on the of material for you too. You want to talk about alone? Milord, thank you. You are doing well. You are doing very well. God bless you. We are grateful. Certainly the list, the national list. And that is why we call our senior advocate of Nigeria, who happens to be our incoming president. Is it at the first now? At the first president of the Nigerian Bar Association. Gentlemen, you want to clap, please. Let's give them a round of applause. Let's give him an representative a round of applause. Thank you for coming and thank you for your contribution. God bless you. Thank you very much. MC, I hand over to you. Continue. There are many dignitaries already. Go ahead and introduce them. Thank you. We take a photograph. Take a photograph, please. Take a photograph.
While we are getting ready for the group photograph, I did promise you that we are blessed. We are very blessed in terms of the panelists that we have had over the days, yesterday and today. Today is yet another. It's yet another. And I hope nobody is going to miss what we're about to have today now, which is section 5. And in this section 5, we have Milords already here, seated. So I'm going to introduce Milord. But I also want to let you know, because during the tea break we had a schedule that indicated for the disabled. But we are going to find the time and then I'll find out whether they will just make the speech regarding that. That was supposed to be connected to the tea break. But meanwhile, I have the honor to invite my Lord Honorable Justice Suleiman Galadima. Please, as I call, I would like you to appreciate them as they come to justice. Obviously, from the child and member of this NJC. He is the chair of the Independent Investigative Panel on Human Rights Violations as it defends Special Anti-Robbery Squad Stars and other specialized units. In this particular